clarifying that its June 29 stay order only pertained to 50% horizontal reservations for Delhi locals. The Delhi High Court directed National Law University, Delhi to issue an addendum to its admission notifications. In its revised admission notification dated June 30, NLU Delhi had removed 50% horizontal reservations for locals as well as 22% reservations for the OBC in Delhi region and 10% reservations for EWS.
Delhi High Court has allowed the National Law University Delhi to correct the error of removing vertical reservation for OBC and EWS categories in its admission notification and place a revised notification before the court. While noting that the university has misinterpreted the order of the court dated 29 June, wherein a stay was imposed on 50% domicile reservation, the division bench of Justice Hima Kohli and Justice Subramaniam Prasad clarified that the said order was only restricted to domicile reservation and had nothing to do with the vertical reservation. The order has come in an application moved by Delhi government before challenging the admission notification issued by National Law University Delhi so far as it eliminates vertical reservation for other backward classes, OBC and economically weaker section EWS categories. While rapping the university for misinterpreting its order dated 29 June, the court said, "You have squarely botched up the order. You are having a selective reading of your order as per your assumptions and creating a mess for the students. We expect better interpretation of orders from law school. You have chosen to undo things that shouldn't have been undone." Meanwhile, NLU Delhi informed the court that if they allow vertical reservation for aforesaid categories, they won't be able to provide hostel accommodation to all BA LLB students as there are infrastructure constraints. The university, however, did admit the fact that it had misunderstood the order of the court and that it is willing to issue a fresh admission notification within a week. The Delhi government had submitted that the decision of the university to eliminate 22% reservation for OBC and 10% reservation for EWS in its admission notification released on 30th June is not only the incorrect interpretation of the court's order dated on 29 June, but it also goes against the university constitutional and statutory obligations. It was submitted that the present writ petition only concerned within the 50% domicile reservation and had nothing to do with the vertical reservation for OBC and EWS categories. It was argued in the application that the university is statutorily bound to provide vertical reservation to OBC under Central Educational Institution Reservations in Admission Act 2006. Bureau Report.